Assalamualaikum and hi. Today we would like to present about summary judgment and review the case of YTL Cement Sdn Bhd against Sdn Bhd and Bina Puri Sdn Bhd. This is our group members. The first one is introduction. Plaintiff of this case is YTL Cement Sdn Bhd, and the defendants of the case is Sdn Bhd, which is the first defendant, and the second defendant is Bina Puri Sdn Bhd. The jurisdiction of this case is in the High Court Malaya at Kuala Lumpur, and the judge who decide this case is Learned High Court Judge Aliza Sulaiman. The provision that related to the case is Order 14, Rules 1, Rules of Court 2012. Next, fact of the case. The first defendant purchased cement-based product from the plaintiff on 27 April 2016. Then, on 14 July 2016, the second defendant agreed to provide a corporate guarantee on behalf of the first defendant until 31st December 2018. The corporate guarantee automatically made the second defendant liable towards the debt of first defendant. The plaintiff then sent notice of demand to both defendants on 21st November 2018, demanding for some money and interest. However, the first defendant paid, but failed to pay the full amount of debt, including the interest. On 12 September 2019, second notice of demand had been issued and sent to both defendants. However, there is no response from both defendants. Next, on 10th October 2019, the plaintiff filed a writ of summons and statement of claim against the defendants. Then defendants submit their defences on 7th November 2019. Lastly, on 22nd January 2020, the plaintiff had applied for summary judgment and the application had been granted.
Assalamualaikum and a very good evening. My name is Muhammad Izham and my metric number is 2558890. So we continue our discussion in the part of legal and application in the case of YTL Cement against Easy Mix and Bina Puri Holdings. So civil suits takes a longer time to be settled and finished as compared to criminal matters because the set of procedural rules governing the civil suits takes a long time to be processed and to move on to the next stages to ensure that both parties have been rightfully contested, and also to ensure that a fair decision to be obtained after the court has determined all the evidence and the details before reaching the final decision. So the 14 of Rules of High Court 2012 provide a mechanism referred as summary judgment to cut short the time and completion. Summary judgment is a set of procedures to obtain judgment at a very early stage of the proceeding without proving the case at the trial. This may be applied by the applicant, the plaintiff, when the plaintiff has an unanswerable claim against the defendant. The judgment is a set of procedure device available for prompt and expeditious disposition of an action by the plaintiff or a counterclaim by the defendant without trial when there is no dispute of fact or law. In Jacobs vs. Bush Distillery Co. 1901, the judge clearly explained the importance of Order 14 to prevent delay to the judgment and avoid incurring more expenses when the case can be settled without needed to enter trial. So general procedure to summary judgment have been provided under Order 14, Rule of Court 2012, which begin with the writ and cannot be claimed by the plaintiff for libel, slander, and malicious prosecution, and many more, which has been provided under the Rule 1, Order 14, Rule of High Court. There are two methods to rebut the summary judgment, which is firstly to raise the defendant may raise a tribal issue, which the defense or claim of defendants carry some degree of conviction that makes the defense claim to be more than merely arguable. And the second method is to raise defense in technicality to prove that the plaintiff did not comply with the procedures and requirement provided under the rule of courts. So, in this case, YTL Cement Marketing versus Easy Mix Sdn Bhd and Bina Puri Holdings, YTL Cement has made application for summary judgment when the defendants failed to settle sums for supply of cements to the plaintiff in two separate notice of demand, namely 2018 demand and 2019 demand, which has been served to the defendants. The plaintiff also has fulfilled the requirement before summary judgment and fulfilled the preliminary requirements for proceeding under Order 14. Therefore, the High Court have shifted the burden to the defendants to raise any tribal issue or reasons to there be a trial. defendant submitted the summary judgment is not appropriate on three triable issues, which are firstly, the inaccurate principal sum claimed by the plaintiff, the invalid late payment interest charged by the plaintiff, and second, defendant liability under corporate guarantee has lapsed. Thank you.
My name is Rahmana, metric number 255980. So the first issue in this case is that whether the principal sum claimed by the plaintiff is inaccurate or not. Here, the defendant argued that the sum claimed by plaintiff were inconsistent based on two reasons. The amount stated in the August 2019 statement was different with the tax invoice that they have received. Next, in the August 2019 statement, the accrued interest was as of 16 August, which was different in the 2019 demand, which is that it was as of 31st July 2019. The defendant also claimed that the calculation made by plaintiff was never explained, therefore making it inconsistent and also disputed. The defendant argued the amount of principal sum is a triable issue by referring to the case of Puri Sdn Bhd and also the decision in YTL Construction Sdn Bhd. The plaintiff in this case emphasized on the fact that the defendant did not complain in regards of the discrepancy of the sum claim. The plaintiff also pointed out that the authorities in the case of Puri Sdn Bhd and YTL Construction can be distinguished on the fact, and it is not applicable in this case, as of defendant 1 has already made payment to set off a part of the sum that he owed. The plaintiff also pointed out that the cause of action was due to breach of agreement in credit application, and it was not because of payment by defendant 1 was compromised. Here, the court was in favor of the plaintiff and found out that the issue does not amount to a triable issue. The court stated that defendant 1 has agreed to accept the trading term of plaintiff and the good has been set. Therefore, the court found that the amount claimed by plaintiff in 2018 demand is consistent with August 2019 demand, and the issue of inaccuracy of principal sum does not amount to a triable issue.
Assalamualaikum sir, my name is Nur Ain Syafiqin binti Muhammad Rozi. My metric number is 252695. So I'll continue with the second issue in this case with the court decision and also the reason behind the judgment. So the second issue discussed in this case is whether the late payment interest charged by the plaintiff towards the defendant is valid. So the defendant had cited two cases, which the first case is the case of Nisha Industrial and Trading Sdn Bhd and Cocoa Floor Sdn Bhd and another, and the second case cited by the defendant is the case of BHS Book Printing Sdn Bhd and Penerbitan IMT Sdn Bhd. So for the first case, the defendant claimed, referring to the first case cited by the defendant claimed that a seller, in that particular case, a seller is not allowed to charge late payment interest in the absence of buyer's knowledge. And for the second case cited by the defendant, in that particular case, mentioned that the imposition of the late payment interest of 1% per month is exorbitant. So here, the defendant want to claim that the plaintiff had acted unjustly in imposing the late payment interest charge toward the defendant. The plaintiff, however, rebutted that there is a credit application where in that credit application stated that the first defendant had agreed to allow the plaintiff to charge the interest on all the outstanding debt at the rate of 1.5% per month, and then there is also a corporate guarantee where the second defendant had guaranteed as principal debtor to pay the outstanding amounts, including the late payment interest. It clearly stated under the corporate guarantee. And also, the defendant also had made the part payment of RM 550,000 ringgit Malaysia, which clearly shows that the interest rate chargeable was never disputed. Because why pay if there is dispute, right? Like the defendant just pay. Okay, for the second issue, the court held in favor of plaintiff because there is an agreement between the plaintiff and the defendant where preceded the supply goods by the plaintiff to the first defendant proving here that the defendant had agreed if the plaintiff charged the late payment in interest to them. And then there was also a document signed by the director and the secretary of the second defendant that clearly showed that the director had given the approval for the second defendant to act as a corporate guarantor. And as a corporate guarantor, of course, you have to pay the outstanding debt or the outstanding amount. And then the court distinguished the two cases cited by the defendants because both cases cited by the defendants, the fact of both cases is far from similar from the case that being discussed from what being discussed now.
Good morning everyone, my name is Nurizlin Roslan, metric number 254211. So for today, I will be talking you guys through the third issue that was brought up by the defendant in their pursuit for trial, which is whether defendant 2's liability under the corporate guarantee has lapsed. So, the defendant argued that the plaintiff has no ground to take action against defendant 2 since the CG was only valid from 14 July 2016 until 31st December 2018. And the plaintiff brought this action fully based on the demand that was made in 2019, which is way after the expiry date of the CG. Hence, this limitation period should be taken into account. The defendant also argued that all demands shall be made properly in writing and received by defendant 2 within the time. However, defendant 2 has not received anything of that nature. So defendant 2 should be relieved of all their obligations. The defendants also cited the case of the Pacific Bank Berhad against Kerajaan Negeri Sarawak, in which summary judgment was not granted by the federal court because the demand was made after the expiry date of the CG. On the other hand, the plaintiffs argue that since defendant 2 has agreed to unconditionally be liable as a principal debtor, defendant 2's liability is indefinite, which means that as long as the sum was not fully paid, defendant 2 still can be held liable for the payments. The plaintiff further argued that they had made a demand in 2018, but defendant 1 only managed to pay half of the demand, leaving behind a balance, which resulted in the 2019 demand. Plaintiffs also cited the case of Orang Kaya Menteri Paduka Wan Ahmad Isa Shukri bin Wan Rashid against Kuang Yi Bank Berhad, which set the rule that in order for a summary judgment to be granted, a proper demand must has been made first. Next, they also cited the case of Chong Yong Choi against UOL Factoring Sdn Bhd. Defendants just made a bare denial to evade payments. So, on to the judgment. The court ruled in favor of the plaintiff with regards to this third issue. The plaintiff managed to prove that they had indeed met their claim within the time covered by the CG. The court also rejected the case cited by the defendants, which is the Pacific Bank Berhad case, because in that case, the demand was made 6 months after the expiry date of the CG, so it is only fitting that summary judgment was not granted. Meanwhile, the court agreed to take into account the legal principle laid down in the case of Chong Yong Choi, which was cited by the plaintiff. Plaintiff has entered into the agreement with defendant 1 due to the encouragement from defendant 2 to be the principal debtor. Therefore, it is within the right of the plaintiff to hold them accountable. That's all from me. Thank you.
I would like to present on the commentary part. By looking at what has been decided by the judge, the court is correct by giving summary judgment to the plaintiff. Gopal Sriram once said that Order 14 should be used only in instances where there are no authentic tribal issue, but in this case, defendant failed to show that there is authentic tribal issue in plaintiff claim. The court, we believe, that was being comprehensive by checking into details in the exhibit and being flexible in deciding the case when the defendant alleged that plaintiff is inconsistent. For example, it can be seen when the defendant stated that the August 2019 statement with the tax invoices is in inconsistency and tried to bring up the issue of oral evidence is vital to resolve the inconsistencies. Later, plaintiff gave justification that the amount was used to deduct the principal sum of the invoices and had been agreed by the court. We also agree with the court that plaintiff is correct when the plaintiff notified the defendant if there is any disagreement, they should be notified within 7 days, but defendant failed to do so. We strongly agree with the approach used by the court, where it was decided equitably. Therefore, we assent to what has been decided by the court when the issue of late payment interest charge was raised. The judge had looked into the documentary evidence that has been signed by D1 Executive Director, as it gives right to the plaintiff to charge interest on outstanding debt at the rate of 1.5% per month, as it will be occurring after the end of 30 calendar days of the debt. From here, we believe that the court was accurate by following the important evidence, which is the credit application. The court here using the literal approach, where it looks primarily at the words of the document to construe its meaning. Hence, the court has a solid decision when the court distinguished this case with Nisha Industrial and Trading. The court shows the differences and cited the similarity in the case of BHS book printing to strengthen the court's finding. Lastly, the court has made the right decision in stating that it is unacceptable for the defendant to raise the issue of D2's liability under the CG has lapsed. Court has precisely said that the demand made against D2 was still within the duration covered by the CG. Hence, the balance of the principal sum amounted to 1,238,012.21 is still before the final claim date ended. The court had looked into the case of Chong Yung Choi and agree with the remark of the case. All in all, we praise how the court decides the case fairly by looking into the details of all pieces of evidence and authorities. The reasoning made throughout this case need to be emulated by all.
Okay, lastly, as for the conclusion, summary judgment is an application that is filed by the plaintiff against the defendant without having to go through trial and testification from the witnesses. However, the defendants also may file for the judgment to counterclaim the plaintiff. In Order 40 Rule 1, Rules of Court 2012 provide that the plaintiff has right to apply for summary judgment when the statement of claim has been issued for the defendants but there is no response or defenses by the defendants to such claim. In this case, the plaintiff had required and fulfilled all the procedural steps before applying for the summary judgment. The right of plaintiff, the summary judgment also is the right of plaintiff to avoid having a trial, call for witnesses, and identifying evidence against the defendants. That's all for today. Thank you. If there are any questions, you can type in the chat box so that we can answer your question. Thank you.